Morning everyone, Rod Culleton. I just wanted to give a quick update on my Facebook today to inform everyone of my position as it stands at the moment. I just would like to let the people, or certainly my followers, know that I received the other day a 78A notice from the Attorney General whereby the government is putting me simply back into the High Court, or intervening in a matter before the High Court, which is P43 and P44, over the eligibility of me being a duly sworn elected senator. However, I have written a response back to the senators, to the High Court, and to Andrew Phelan, who is the principal registrar of the High Court, and certainly the financial minister, over the purported $700,000 amount of money that the government believes that I owe them over my staff wages and expenses. Simply, while matters are still before the court, we need to just have to park them to one side. But what is more important is I'm not going to consent at this point to the waiver, because the waiver is not something that is actually been offered to me. It's only consideration. So even if an application was made, there is no guarantee that the government is going to accept my application. But I wouldn't be making that application because I'd be taking the rights away from my staff. My staff, who are very experienced, loyal workers and great team members, left positions. They were headhunted, they left positions, and they came and worked for me, which I was very proud to employ them in my staff office. They have been left without a job. They were given less than 2 weeks to vacate the office, and I will not accept any waiver at this stage to take away any rights from those individuals. But what is more important is I have filed documentation into the High Court over the declaration and the process which was used by Attorney General George Brandis on the 7th November, and I urge people to go and have a look at the transcript. There was no facts, no evidence, nothing put before the Senate that day. I was simply rushed off down to the High Court, and my party leader and my other colleagues supported that motion. There is no petition, it was only a referral, and to engage the Electoral Act you need a petition. The Electoral Act, we've asked for the petition, and we've also asked the High Court for the petition, and they have come back and said there is no petition. So that puts a big question mark over this whole process. But what is more important is the High Court 5 justices at paragraph 6 altered the act of the Crime Sentencing Procedure Act, and it was to do with the pocket key and the Armidale matter. And that was, they removed must not impose an order for sentence to an absent offender, and they replaced it with may not. And that is absolutely an alteration of an act, and this is why the High Court referral or declaration cannot be accepted as an instrument to remove me from the Senate. I just want to also make it very known that my party leader and my other colleagues could have revoked that referral when I explained the facts, the agreed facts, and that and all the material that has always been on before them in relation to the Armidale matter. They could have revoked, and they, on the basis that they have a sworn public duty to uphold the law, and at no point could I ever be sentenced or found in breach of grounds 44 of the Constitution. So look, please keep in touch. It is not finished. It also must be put on to the public that there is all the High Court professors around Australia, including Justin Gleeson, who gave the opinion to the Attorney General at the time, is going to hold a seminar in Melbourne at the Melbourne Law University to discuss my matter, and others of course. So look, it is very interesting times, especially in relation to the Constitution. This is certainly a case precedent that needs to be amended, because any senator, and certainly now a lot of people are coming under scrutiny of Section 44 Roman 2 of the Constitution. So I'll be in touch. I also want to let people know that evidence will be given. I'm giving evidence at the banking inquiry, which I'm looking forward to, and in relation to drumming up the Royal Commission. But thank you very much, and I'll keep in touch. Thank you.